Yes, Mr. Ratton.
My lords, my lady, before the break, we were descending into the respondent's notice in respect of ground 1. I'd outlined the 3 areas that fall to me to address, the first of which is Article 1, Protocol 1, ECHR.
Yes, we were going to go to P. Was that
Indeed, yes,
where we're going?
That's quite right. If we could maybe turn that up. It's in the Authorities Bundle, Volume 6, tab 54.
Thank you.
And the relevant passage is paragraph 17, which is internal page 226 and bundle page 1478. If I could invite your lordships first, I think, to read paragraph 17, I'll then draw some points out of it. Well, I'm grateful. We're not concerned with the first of those aspects, the accessibility test, because obviously Section 55L is published. We're concerned with the foreseeability criterion. And as to that, as Lord Sumption here explains, it's essentially concerned with the principle that one should have government of laws and not of men. And for that reason, a measure is not in accordance with law if it purports to authorise an exercise of power unconstrained by law. The measure must not therefore confer a discretion so broad that its scope is in practice dependent on the will of those who apply it rather than on the law itself. And I'd underscore the point by letter G. Its relevance in that regard to take into account both the breadth of the measure and safeguards for the rights of individuals. There's just one other passage to draw your attention to, which is in paragraph 24 of the judgment, which is internal page 231, bundle page 1483. And you'll see there by letter E, this is quoting with approval from the previous case of Gillen and Quinton. What they say by letter E is that the level of precision required of domestic legislation, which cannot in any case provide for every eventuality, depends to a considerable degree on the content of the instrument in question, the field it is designed to cover, and the number and status of those to whom it is addressed. And my lords, by reference to those principles, we say it can't be suggested that Section 55L amounts to government of men rather than laws, or that it lacks the quality of law. And we've addressed that in the FCA's reply skeleton at paragraph 9, but if I might just bring out the key points. First, as to the breadth of the power, this isn't an untravelled power in the sense that it can only ever apply to the regulated community, i.e. those who are already authorised persons, or those who are seeking authorisation. And you saw that in Section 55L, subsection 1, which you were shown by Mr. George earlier today. Second, as to the substantive scope of the power, you have my submission that it's not an unconstrained power. It has clear and express conditions stated on its face by reference to the FCA's statutory objectives, which are themselves defined in statute. Thirdly, and as I've just shown you, it's relevant to take into account the procedural safeguards that exist in respect of the power. And as Mr. George has shown you, in respect of the Section 55L power, there's both a statutory right to make representations and also a right to refer the matter to the Upper Tribunal if the subject is dissatisfied with the decision that's been made. And so for all of those reasons, we do consider it clear that Section 55L has the character of law. This is a statutory scheme conferring a carefully delineated statutory power on a specialist regulator, exercisable against authorised entities and subject to a statutorily mandated process to ensure procedural fairness and a right of referral to the tribunal. And it's unsurprising that none of the authorities that BlueCrest has cited in relation to the in accordance with law criterion bear even the slightest similarity to the facts or the legislative regime with which your lordships are concerned. And for your note, that's in BlueCrest Skeleton paragraph 57. I might just give a very brief potted summary of those 3 cases so you can get a flavour of what they're about. The first is East-West Alliance in the Ukraine, which involved a complaint by an applicant whose aircraft had been seized by the state of Ukraine. The states had declared the aircraft ownerless and authorised their sale to third parties on that basis. The applicant company had begun a judicial challenge to the decision to declare the aircraft ownerless, but the state nonetheless authorised the sale. The state further declined to enforce any final judicial decision which had been made, ordering the return of the aircraft, and perhaps unsurprisingly that was held to be in breach of A1P1. The second case is Baylor in Italy, which was the expropriation by the state of Italy of a Van Gogh painting at well below market value and after a delay of some 5 years. And the third is Hendrick in France, which is expropriation of land by the French tax authority without giving any reasons and without affording the applicant an adequate opportunity to make representations. So none of those involve anything like the kind of procedural safeguards or statutory criteria with which your lordships are concerned. I'd note, in fairness to Mr. Herberg, I don't think it's suggested those facts have any comparability on their, those cases have any comparability on their facts. They're relied on for the abstract definition of what the in accordance with law criterion constitutes, and for that reason they're not in the bundle because those abstract propositions aren't in dispute. I make the offer with some reticence given the number of authorities in the bundle, but obviously if it would be of assistance, we would be happy to provide copies of those cases. My Lord, remaining with the in accordance with law criteria just for a moment, one could usefully sense check BlueCrest's argument by considering the statutory definition of the FOS's jurisdiction, which you were shown earlier today, and as you'll have seen is a test simply by reference in section 228 FSMA to what's fair and reasonable in all the circumstances of the case. And it's well established that the FOS, for that purpose, is not required simply to have regard to the law and regulatory standards. It can make a wider-ranging assessment of what it regards as fair and reasonable. And the logic of what BlueCrest is saying, if it's correct, as to what the in accordance with law standard requires, would seem to have no rational basis for distinguishing the FOS scheme, which is referred to by BlueCrest and not suggested to be in any way impeachable, from the section 55L power. Further, it's uncontentious that the in accordance with law criterion can be satisfied by reference to published guidance as well as legislation. BlueCrest contends that the FCA has no relevant guidance in place, and we say that's wrong. For your note, probably in the interest of time, I can give you the reference to the supervisory notice, which itself sets out the relevant parts of the FCA's guidance. That's supplemental bundle, volume 2, tab 11, page 425. I'll have to wait and see what Mr. Herberg says as to why that guidance is insufficient. But what I would note is it's very difficult to see how BlueCrest's arguments based on the alleged lack of guidance can have any rational bearing on the question of statutory construction that your lordships are asked to address under ground 1. Because it can't be the case that the proper statutory construction of section 55L waxes and wanes depending on what guidance the FCA does or doesn't have in place at any particular point in time. My Lord, then the third disputed aspect of the A1P1 analysis, which concerns proportionality. You have my point, that's not something which can be determined on what was an application for strikeout. It's an intensely fact-sensitive inquiry. But I can in any event deal with it briefly. BlueCrest's submission in this regard is in its skeleton at paragraph 60, and it amounts simply to the assertion that it's disproportionate to require a redress that does not compensate for any loss. But that's repetitious of their underlying argument that the redress requirement doesn't identify any loss. And as I've explained at the outset, they lost on that point before the tribunal, and to the extent necessary, you'll be hearing about it later. But it doesn't add anything distinctive under the heading of proportionality. It's the same argument. My Lords, then moving briefly to the second of the areas that I outlined at the beginning, which is BlueCrest's reliance on common law principles. BlueCrest skeleton paragraphs 61 and 62 relies on two principles. First, what's described as a principle of legal policy, that property or other economic interests should not be taken away, impaired or endangered except under clear authority of law. And second, the principle against doubtful penalisation. We've responded in the FCA's reply skeleton at paragraphs 14 and 15. In summary, the conditions for the exercise of the section 55L power are clearly stated on its face. They do provide clear authority of law. And indeed, it's BlueCrest's case on construction which is seeking to interpolate further conditions in that aren't apparent on the face of the statute. And so we say that insofar as there's a need for clear authority, that's what section 55L provides. And you can again sense check it against the section 228 FOS jurisdiction, which again, no suggestion as I understand it that that's in any way incompatible with the common law principles, and is, if anything, a less specified standard, simply a fair or reasonable standard. As for the principle against doubtful penalisation, we don't see how that has any logical application in this case, because a redress requirement by the FCA is neither a civil nor criminal penalty, it's compensatory in character. And so we say it doesn't have any application, but to the extent it did, the words of the section 55L are clear and determinative. And just briefly and finally on those common law principles, it's relevant to return to one of the overarching points I made, which is what BlueCrest is seeking to derive from these principles. Because it can't be the four conditions. The four conditions isn't just loss and causation, it's actionability, and it's this correspondence requirement, correspondence between the person to whom the duty is owed and the person by whom the loss is suffered. And there's not a word said as to how those conditions of that detail and specificity could be derived from the need for a clear authority of law. Finally then, and also briefly, the third of the areas I outlined at the outset, which is the alleged unlawful exercise of power by the FCA for an improper purpose. You can see BlueCrest's submission on that at paragraphs 64 to 66. And once again, effectively the argument is that it's unlawful and improper to require a redress if this doesn't compensate for any loss. But as I've outlined, that's entirely repetitious of their underlying argument that there is no arguable loss identified. And for your note, we address that in the FCA's reply skeleton at paragraph 18, on which we rely. And my lords, my lady, subject to any questions that you may have, that's what I propose to say on those respondents' notice points.
Yes. Thank you.
My lords and my lady, those are our submissions on the statutory construction point insofar as it relates to redress. There is clearly then a subsidiary point, which is if I'm wrong and the four conditions are incorporated into the statutory test, am I able to satisfy them? And I will, if I may, return tomorrow morning to the point on the first three conditions, because it's a cross-appeal point, and my broad submission will be on the point on these points on which I succeeded, that we are right for the reasons the tribunal gave. But on the fourth condition, actionability, as this court has already pointed out, I do need an amendment, and subject to this court's permission, I would now turn to look at the second limb of the appeal issues, which is the jurisdiction of this tribunal to permit amendments to statements of case.
Yes.
So, my lord, firstly, and I hope briefly, I will introduce the amendments, as it were, because in a sense the points of principle to which they give rise go a lot wider than merely the context of this case. But may I first invite your attention to the unamended pleading at Supplementary Bundle 2, page 474. There's obviously a wealth of detail in the underlying case, and this court has seen it summarised in the tribunal's judgment. But four important provisions in my respectful submission. Firstly, here, paragraph 15. On the unamended case, we simply contend that the applicant has breached Principle 8 during a relevant period, and that is the only case alleged. At page 504 of the bundle, the annex to this pleading, a firm must manage conflicts of interest fairly, both between itself and its customers and between a customer and another client. So clearly an issue that arises is who are the clients or customers to whom we say these duties were owed and breached. Our position, which is contested, has always been that our case has been clearly pleaded. We say the clients and customers are both the external fund, as it is known, i.e. the entity which constitutes the fund that was managed by BlueCrest, and the investors in those funds. Those are both the applicant's clients. And we are entitled to bring our Principle 8 case on both bases. And we say, as I say, this is contentious, we have always so pleaded. And that's at paragraph 476 of the bundle. Sorry, page 476 of the bundle, paragraph 42. We say the funds and their underlying investors had professional client status, and that makes them both a client and a customer. Customer is a client who is not an eligible counterparty, which doesn't arise here. So for our Principle 8 case, we say we had always pleaded that they were both clients, and then at paragraph 173, that the breaches affected the applicant's failure to manage this conflict resulted in a substandard investment management service being provided to the external fund and its investors in that the service provided involved both the inadequate arrangements and the inadequate disclosure described above. And we can look at the detail in as much as necessary, but there are and always have been two parts to this unamended case: the inadequate arrangements and inadequate disclosure to both the external fund and the external fund's investors. Now, my lord, my lady, that gave rise to various criticisms that in fact we hadn't managed successfully to plead a proper case that had them both as clients for prenate purposes.
Sorry to slow you down. Do we need to understand, because if so I don't myself, quite what the structure is of the external fund as an entity? Is it a legal entity itself?
My lord, yes it is, and in my respectful submission, no, you don't need to understand its structure for these purposes. It's not in dispute that the external fund is capable of being a client, it's legally distinct. What is said is that I didn't manage to plead a case that had both the external fund as a client and the external fund's investors as clients.
Yes, I understand. But external fund is a separate legal entity.
Precisely, my lord.
Right,
That's not challenged.
That's all we need to know. Right.
And so, my lord, if we can then go to supplementary tab 17, page 584. We have a series of amendments. We say make clear the principal 8 case we had always pleaded, namely that we had one in respect of the external fund and also and additionally a case in respect of the external fund's investors. So, my lord, if you see the new 42A, this relates, does my lord see the words in relation to the external fund? So we plead here a number of matters that relate to our prenate case with the external fund as clients. And one of the reasons you do not need to understand in particular that case is because one of the amendments was not permitted and has not been pursued on this appeal. That's C. And the other amendment, D, was consented to and remains consented to. So that, in a sense, you can just park. I have a prenate case using the external fund itself as a client. What has been called the second contested amendment, on which we succeeded below, is what you see at F and G, and that relates to the external fund's investors. And what we do in these two subparagraphs is two things. At subparagraph F, we set out what we say the breaches are, and we make clear that they are the same breaches that have been relied upon in the unamended case. This amendment only identifies who the client is. We say it was always there. If necessary, we plead to clarify it. But there are no new breaches, no new facts relied upon as constituting a breach. They are simply that which was set out and was always set out at paragraphs 81 to 102 of this pleading. Why are the external funds investors clients? In a sense, my lords, my lady, that does not matter for today's purposes because it's not in dispute. It's a slightly convoluted part of the regulatory provision in that the external funds, the investors, the individuals who invest in the external fund, are deemed clients for the purposes of the regulatory regime because, and it's set out in 1 and 2 there in little f, the applicant provided services in the course of making arrangements with a view to transactions and investments and or arranging, bringing about deals in investments. Further, alternatively, little 2, communicated or was likely to communicate financial promotions to the firm's clients, the recipients of these, and or likely recipients of those communications being for these purposes, the firm's clients.
Sorry, the words in italics, they're obviously a citation.
Yes.
From somewhere.
They are from what is known as the Regulated Activities Order.
Oh, so that's the link.
Precisely. It is because these people received that service that they are deemed clients of BlueCrest. Even though BlueCrest might not, absent the regulatory regime, have considered them as clients, because at that stage there wasn't a contract. This is pre-contract. And similarly, it is the result of a deemed regulatory provision that those who receive financial promotions are a firm's clients.
Which bit of the RAO is it? Come back to it. If
Yes.
maybe I just want to make a note.
I'll say, if I say Article 22, I might be getting it wrong, but it's about there. And the financial promotions provision is in COBS 3.2, and you might just be assisted by turning that up at page 31, at paragraph 312 of the authorities bundle. So, does my lord, my lady, have COBS 3.2, page 312, a person, general definitions of clients? So, general definition, a person to whom a firm provides, intends to provide, or has provided a service in the course of carrying on a regulated activity is a client of that firm. And I'll get you the exact reference to the RAO, but these parts in italics are from the RAO and they satisfy that definition. And on subsection 3, what 2 says a client includes a potential client. 3, in relation to the financial promotion rules, a person to whom a financial promotion is or is likely to be communicated is a client of the firm that communicates or approves it. So as you see, my lords, my lady, it is a deemed provision, as it were. They are clients because these factual matters occurred. For the purpose of this amendment, none of that is challenged. It may or may not be at trial, but that's accepted. The reason it is said by way of cross appeal that my amendment should not be allowed is simply because it's coming in too late and not at the right stage of the proceedings. But what I draw attention to is that the amendment as pleaded in F and G merely particularises the specific reason that these people are clients and customers for crinate purposes. It does not change the substantive allegations of breach. They remain exactly the same because they were always pleaded on this basis. See paragraphs 81 to 102. And if I just make that good, my lords, by turning to page 590. So these are the substantive, the unamended, I mean, you can see the amendments there in red. Pursuant to the MSA, the applicant was appointed by the investment manager to market and sell subscriptions for investment in the external fund. This included the applicant providing presentations and issuing marketing materials to prospective investors in the external fund. Remembering a client includes a potential client. These responsibilities were primarily carried out by the applicant's sales and marketing team. And this court does not need to, as it were, go through the detail of the following paragraphs. They particularise the financial communications which we said in the unamended case, and all have always said constitute a failure, a breach of Principle 8. And my lord sees the way the pleading tracks through at paragraph 168. So there's the inadequate disclosure part of the case, and you can see the unamended part and the amended part. And then at paragraph 185, which is on page 604, the specific harm at 185, the applicant's failure to manage the conflicts surrounding the allocation of portfolio managers resulted in a substandard investment management service being provided to investors in the external fund. The harm caused to customers was compounded by the insufficient detail within related disclosures, which denied investors the opportunity to make informed decisions regarding their prospective or continued investment in the external fund. So, my lord, that's the second contested amendment. And as I say, the points that arose below and on appeal do not relate to whether that is sustainable in law. It's accepted that it is. It relates to whether it either the tribunal had jurisdiction to permit that amendment or should have exercised its discretion to do so because of the stage at which the amendment was raised. And as I say, I succeeded on those issues below, and that forms part of the cross appeal. But we then have two amendments that were not allowed, my lord, and they're called the third and fourth contested amendments. And they're back at page 585, and it's paragraph 42b. So my lord sees here, further alternatively, as a result of the matters set out in paragraph 42af above, the external funds investors and or prospective investors were clients and or customers of the applicant for the purposes of the obligations in Principle 7 and or COBS 4211R. So these are different regulatory rules to Principle 8, and in a sense that's the point, and the point on which ultimately I lost. It may assist this court if we just look at them briefly at page 396 of the authorities bundle to start with. So there's Principle 7, communications with clients. A firm must pay due regard to the information needs of its clients and communicate information to them in a way which is clear, fair, and not misleading. And the definition of clients I have shown you earlier, and you'll see from the pleading, is cross-referred back to what we say in relation to Prin 8. So the people who received this marketing material were clients for both Prin 7 and Prin 8 purposes. And then we go to page 314 for the COBS rules. As this court may be aware from various authorities, the regulatory structure has these principles sitting above it, the ever-present substratum, as it's been called, of the regulatory regime, and then more detailed and specific rules sitting below them. So COBS, conduct of business, are part of those rules, and my lord sees at page 314, this is COBS 421, a firm must ensure that a communication or a financial promotion is fair, clear, and not misleading. Really the same terms as Principle 7. And if my lord is wondering why have both, or what's the point of all this, in our submission, I don't think this is contested, COBS 4.2.1 is actionable for the purposes of the redress regime. So that is a particular reason for raising it, and we have always been quite clear it is the reason that we seek to introduce it. Now we have been adverted to the construction arguments on the redress scheme that my learned friend runs and has succeeded on before. But the principal submission which I make, and where the tribunal in our respectful submission fell into error, is, well, there's two parts. Firstly, we say that changing the legal label by which we characterise the relevant breaches cannot be, is not something which falls outside the tribunal's jurisdiction to permit. And I accept entirely we're changing from Prin 8 to Prin 7 to the COBS rule. They are different rules. But that is all we are doing in my respectful submission. We are not otherwise changing in any way the nature of the case, because our conflict of interest Prin 8 case, the unamended case, has always been based fairly and squarely on the inadequate communications, the inadequate disclosure, the fact that the communications were unfair, unclear, and misleading.
Sorry, was that, you say that's always a case about inadequate disclosure to investors rather than to the directors?
I'm sorry, rather than to the external fund.
Yes.
Yes. Both, we say both have always been part of it, but for the purposes of these amendments, it's the investors that matter. And the reason I say that that has always been part of the case is particularly because of what is said at paragraph 81 of the pleading at page 590. Pursuant to the MSA, the applicant was appointed by the investment manager to market and sell subscriptions for investment in the external fund. This included the applicant providing presentations and issuing marketing materials to prospective investors in the external fund. So that has always been part of the PRIN 8 case. If I summarise it colloquially, you failed to manage the conflict of interest because your communications were unfair in that they failed to make the appropriate disclosures. All we are doing in the PRIN 7 and Cobb's case is relabelling that as a failure to provide communications that are not clear, not unfair and not misleading. And if I can make that good to the court by just looking at what the substantive new claim I wish to bring in is, and that's at page 602, paragraph 170A. Further or alternatively, the applicant failed to communicate information to investors and or prospective investors in the external fund in a way that was fair, clear and not misleading, and that it failed when communicating information to investors and or prospective investors to whom it was making financial promotions, as set out at paragraphs 81 to 102 above, to inform those investors of either the nature of the conflict between the internal fund and the external fund, or the absence of adequate arrangements to manage that conflict fairly, as set out at paragraph 157 to 167 above. So the substantive breach, the substantive charge that I seek to introduce by the third and fourth contested amendments is simply that because of the matters already pleaded and no other additional matters, you have, and all that's done there at 17A is set out the language of the rule, breached PRIN 7 and Cobb's. Your communications have failed to be fair, clear and not misleading. Now, my lord, my ladies, when one looks at the tribunal judgment, there are clearly two strands of thought that one needs to deal with. The first is that I'm not allowed relabelling at all, but the second is a suggestion that in somehow I'm introducing new facts by the third and fourth contested amendment. And in my respectful submission, I am not. And you can test that simply by looking at whether I am introducing a substantive charge that goes beyond a cross-reference to what I had previously pleaded. So that's what we asked the tribunal to permit.
Sorry, sir. I thought the tribunal, anyway, treated 170A as an amendment to amendment.
170, I think, is part of the third and fourth amendments. So they come in both at 42B and 170A. But the tribunal's objection is that 170A, which clearly refers, it sets out the text of PRIN 7 and the Cobb's rule. I mean, that's what 170A does. Their objection was that because it was relying on a breach of different rules, that took it outside what it called a hard edge to the jurisdiction of the tribunal.
Is that what you've called your relabelling point?
My tertiary case, yes.
Yes.
But I wanted to show you the amendments up front. In a sense, there are wider points of principle that arise on the primary and secondary case, but in my submission, it's useful to see at the outset at least what we say we are doing in these amendments, and that is just, we say, relabelling. Because there are no new facts and matters being brought in beyond changing the actual rule that's alleged to have been breached. And you will, the decision then is obviously whether that is permissible, and I accept entirely the tribunal, as it has read it, has suggested it isn't. Now there's one other matter, if I may, just to clear out of the way before we look at the the actual legal tests. And that is a matter in the judgment that in my submission is plainly wrong, that it's simply a misconception. And that's at paragraph 173, page 269. So up above is the hard edge analysis, and I'll come back to that, of course. But I just want to say at paragraph 173, it says we should also point out that the authority does also seek to rely on facts and matters which have not previously pleaded in the context of the allegations of breach of Principle 8. The fourth contested amendment seeks to plead at 174 new facts relating to the knowledge of particular individuals to whom the authority seeks to attribute responsibility for the alleged misconduct. And that's then picked up at page 274, at paragraph 199. And going on to page 275. As one my lord see at the end, my lady, at the end of paragraph 199, 3 lines from the end. Third, in any event, the nature of the fact allegation upon which the Principle 7 amendment relies is to an extent different to that contained within the original Principle 8 allegation as pleaded. Now, in my submission, that is plainly wrong because it misreads what we are doing at paragraph 174 of the pleading. And may I show you that at page 603? So here's the, at paragraph 174, here is the unamended case. Based on the facts and matters set out above, the authority contends that the applicant breached Principle 8. Then the third and fourth contested amendments introduced in red. Further, alternatively, the authority contends that the applicant breached Principle 7 and or COBS 4211R. And you'll see the reference to para 170A, which we just looked at. Then this sentence in the unamended case, the authority considers that the misconduct was committed recklessly. And then an amendment, in this regard, the authority relies upon an averse, that you'll see the knowledge of various individuals is pleaded. Now, I'm not sure why the tribunal interpreted in this way, but the words in this regard clearly refer back to the unamended sentence that all of the misconduct was committed recklessly. We were criticised in BlueCrest's reply for having made an allegation of recklessness and not having specified who was alleged to be reckless, so we provided these particulars. But it is not part, certainly not a constitutive part, of what I have called the third and fourth contested amendments. To put it as simply as I can, it is irrelevant for the purposes of whether Prin 7 and COBS 421 was breached, whether or not anything was committed recklessly. It's simply a question of whether a communication was clear, fair, or not misleading.
So, presume you say the recklessness or otherwise might be relevant to the breach of both principles.
Precisely, but it's only relevant to penalty, because whether the penalty was whether the principle was breached is not going to be determined by whether someone acted recklessly, but the appropriate action to take, the appropriate penalty to impose as a fine would be, potentially. And you see that, if I may invite your attention to page 605 of the bundle. And do my lords, my ladies, see paragraph 189.3. The breach was, so this is in a section, I should read 189 first. DEP, that's another part of the FCA handbook, lists factors likely to be considered level 4 or 5 factors. The authority contends the following factors are relevant. 18.9.3, the breach was committed recklessly and that certain members of senior management appreciated the risk that a breach could result from the conflict but failed to take sufficient steps to mitigate that risk adequately. So that recklessness allegation was always part of the unamended case.
Okay, and this is all part of assessing the penalty, is it?
Yes, my lady. for your reference, the heading penalty appears on page 603 above para 176.
And this replicates what was in the decision notice.
Yes, so obviously this amendment to name the people who are said to have acted recklessly.
Yeah, sorry, but what we're looking at 189.
Yes. So, in my respectful submission, if one is looking at, is this relabeling or are there new facts, it's wrong to do what the tribunal did and take this particularisation of the individual said to be reckless into account. That really had nothing to do with these new allegations. It's not a constitutive part of them. It has to do with this assessment of penalty, and it was always there in the first place. And it was consented to, I should add. I mean, that as an amendment was consented to.
So this particular amendment is not the subject of dispute.
No, it was, so the reason I mention it, and it is a little laborious, but it's because whilst most of the tribunal's analysis goes to this hard-edged jurisdictional question of the fact I have changed the rule I rely on, there is this one reference to having introduced new facts. But on analysis, that is a red herring in my submission, because this it only relates to these recklessness points, and they really have nothing whatsoever to do with the third and fourth contested amendments. So from that, my lady, we turn to what I have characterised as primary, secondary, and tertiary or relabelling cases, and I will address you on each of those if I may. But first, just very briefly, if I may ask Ms. Mayor, just to run through and place the relevant statutory provisions which found this jurisdiction.
Yes, Ms. Mayor.
My lord, my lady, before Mr. George addresses you on the substance of penalty, I'll just outline the key statutory provisions that govern the jurisdiction of the tribunal. And starting with the provisions that relate to decisions by the authority, which may then be the subject of reference to the tribunal. FSMA distinguishes between two principal categories of decision. Some decisions may be proposed in a warning notice and then taken in a decision notice, and some decisions are taken by way of a supervisory notice procedure. And the decisions that are the subject of the reference in this case span both categories. The decision to impose the financial penalty was subject to the warning notice decision notice procedure. And I won't turn the provisions up, but provisions that govern that decision are section 206 to section 208. And then the decision to impose the redress requirement, as you've heard, under section 55L, was taken in accordance with the supervisory notice procedure under section 55Y. So starting, if I may, with the warning notice and decision notice procedure, general provision is made about warning notices in section 387 of FSMA. And that is in the authorities bundle, volume 1, tab 4, page 146. And this provides, at subsection 1, for a series of conditions that warning notices must satisfy when they are given by the authority to propose regulatory action. Must state the action which the regulator proposes to take, be in writing and give reasons. And then at D and E there are some provisions about allowing individuals access to information. And over the page at subsection 2, a warning notice must specify a reasonable period within which the person to whom it's given may make representations. So there's an opportunity on receipt of the warning notice to make representations to the regulator. And then at subsection 4, the regulator will then decide, having heard any representations, whether to give the person a decision notice. Equivalent general provision about decision notices is made in section 388, which is over the page, at 148 of the same tab. And you'll see there under subsection 1 a series of requirements that a decision notice must satisfy. Many of them are similar. Must be in writing, give the reasons, and again state, make provision about allowing access to material. There is a new addition to what we had under the warning notices at E, which is now there is a right to refer the matter, which is the subject of the decision notice, to the tribunal, and that must be set out in the decision notice, as well as the procedure that applies. And by subsection 2 of this provision, of page 149, I'm just picking it up from the after the comma. So if the decision notice is preceded by a warning notice, the action to which the decision notice relates must be action under the same part as the action proposed in the warning notice. So in other words, if the warning notice proposes a financial penalty under section 206, as occurred in this case, that falls under part 14 of FSMA. And so it is open to the authority to impose instead, at the decision notice stage, a different regulatory action or penalty under the same part, for example, to issue a public censure under section 205. But it could not take different regulatory action, but it falls under an entirely different part of the Act. And that is important because this is the only express statutory limitation setting out a necessary overlap between the contents of the warning notice and the contents of the decision notice. And in fact, the warning notice is not otherwise referred to at all in this general provision about decision notices.
So, is there how to issue a decision notice without a warning notice? It looks like there might be.
I see that reference there. As far as I'm aware, there isn't. And it's slightly strange because all of the decision notices that we can find under the Act are preceded by a warning notice. And indeed, that's how the FCA operates, as I understand it, in your cases. And then turning then very briefly to the supervisory notice procedure, slightly different, but there are a number of similarities. Supervisory notice is defined under section 395, which is on page 167. And that's at subsection 13, supervisory notice is defined. And at little a, we see there a reference to section 55Y, and that is the procedure which the authority followed in issuing the redress requirement under section 55L. And to show you the procedure that applied, I think it's worth briefly turning up section 55Y, because this is the supervisory notice procedure. And that starts on page 74. Picking it up at subsection 1, you see there this section applies to the exercise of the regulator's own initiative requirement power. That is the section 55L power, as Mr. George showed you earlier. And the first notice that needs to be issued is the one that's referred to under subsection 4, where the regulator proposes to impose a requirement or imposes a requirement with immediate effect. It must issue a notice. Subsection 5, there are various requirements of what that notice must contain. It must give details of the variation, give the reasons, inform the person subject to that notice of their right to make representations to the regulator, and also inform the person of the right to refer the matter to the tribunal. So there is a first difference between the supervisory notice procedure and the warning notice procedure, because it can take immediate effect, unlike a warning notice which merely proposes action, and it can be immediately referred to. There is, though, a provision for the making of representations to the authority, as we've seen in that subsection. And under subsection 7, if, after having heard those representations, the regulator maintains its original decision or a similar one, it must then give a second supervisory notice. So that is the supervisory notice procedure.
As I understand it, we haven't got past the first one in this
That's
case,
exactly
because the matter was referred to the tribunal straight
That's
away.
exactly right. And section 395 is the last provision that I'll show you that governs the exercise by the authority of the statutory notice procedure. And that's at page 165. And these are the requirements that apply both in respect of the warning notice procedure and the supervisory notice procedure. And you see that at subsection 1, and you see the distinction that's made there at little a between the giving of a supervisory notice and at BI, the giving of a warning decision notice. And at subsection 2, it states that the procedure in both cases must be designed to secure that a decision is taken by a person not directly involved in establishing the evidence on which the decision is based. So in other words, to avoid prejudice, the procedures adopted by the authority should be designed to ensure that the task of collecting relevant information, investigating and so on, and the task of deciding whether to issue the notice are taken by different people, at least to some extent, the extent set out here. And subsection 3 provides that this requirement, this distinction requirement, may be waived for supervisory notices in particular circumstances. So that is, if the decision is taken by a person at an appropriate level of seniority, or the FCA considers it, and the FCA considers it necessary to advance operational objectives. Turning then to how these provisions operate in practice, and I will just take this briefly. In order to comply with these requirements under section 395, mandating this degree of internal separation, there is a distinction within the authority between different teams, investigatory teams and decision-making teams. The team which investigates firms and gathers evidence is the enforcement division, and then there is a separate decision-making committee of the authority which takes decisions about whether to take regulatory action. And in most cases, that is the Regulatory Decisions Committee, the IDC. But there is also a senior staff committee, and that is a compliance with the provisions that we've just seen in section 395, which may take certain decisions which are subject to the requirement to give supervisory notice. And in broad terms, the procedure is as follows. Where a warning notice is given, or before a warning notice is given, the enforcement division of the FCA will submit a report to the RDC recommending that that notice be issued. And the RDC will then consider representations from the enforcement division and the person concerned about whether to ought to issue a decision notice. And the RDC will also conduct an oral hearing in which the person who is subject to the proposed regulatory action has an opportunity to address the committee and ask questions. And then eventually the RDC will decide, in light of the material before it, whether to issue decision notice. Now in this case, BlueCrest waived its right on receipt of the warning notice and the first supervisory notice to make submissions to the Regulatory Decisions Committee and took a decision straight to the tribunal. But in other cases it would be after this process, on the issuance of the decision notice, that such a decision could end up before the tribunal. And so the key provision that defines the scope of the tribunal.
But it was the decision notice itself that was referred. It wasn't until after the decision notice had been given.
No.
All that was being waived was the opportunity to make further representations to dissuade the FCA from making the decision notice.
Precisely, my lord, and there's quite a helpful description of that, which we don't need to turn up, but for your note, in the decision notice itself, which is at page 466 of the supplementary bundle tab 12. And so that outlines the process by which the authority issued a decision notice on receipt of information that BlueCrest were not going to make submissions before the IDC.
Thank you.
That gave rise to their right to refer to the tribunal. And you've already been taken to section 133, which is the provision which defines the scope of the Upper Tribunal's jurisdiction. I will just make two short points on it.
Sorry, is that identifies what the tribunal can do in relation to what has been referred to it. But it is the first thing that we need to identify and indeed construe is it the section or the two relevant sections which identify the right to refer things to the tribunal. So I think that is 55Z3, isn't it, for page 77 for the 55L decision.
That's right.
So 55Z32, authorised person who is aggrieved by the exercise of either regulator of its own initiative variation power or say initiative requirement power may refer the matter to the tribunal. And so far as the supervisory notice is concerned, strictly speaking, is what we've got to decide what the matter means there.
Precisely.
And what's the equivalent provision for the section 206 sanction?
Yes,
I think I did find it at one stage, but I've lost it.
So in the bundle, we have 206 and 207, but I think in the course of our trying to shorten the bundle, we don't have 208. And it may be that we can hand that up, because I would think the relevant provision about reference to tribunal is in 208, which is the decision of this provision in respect to the penalty.
Could you just read that out to us
Yes.
whilst we're waiting, so I can just have it in mind?
Yes, so section 208 is the provision about decision notices in respect to 206 penalties. And it's subsection 4, which says that if a regulator decides to, little b, impose a penalty on a person under 206, the authorised person may refer the matter to the tribunal. And that is all that is said. So section 133 is
Thank
page 98. And so this sets out the scope of the tribunal's jurisdiction on reference. We see there that it applies broadly in relation to any reference of the decision of the authority under 1A. Subsection 4 provides that the tribunal may consider any evidence relating to the subject matter of the reference or the appeal, whether or not it was available to the decision maker at the relevant time. Mr. George has taken you through the distinction between disciplinary and non-disciplinary reference. But the key point, my lords, my ladies, is that this provision does not state that the tribunal is constrained in the conclusions it may reach in the absence of a particular allegation in the decision notice or the warning notice. And it is that point on which Mr. George will address you further in relation to our second round of appeal.
Thank you.
So, my lords, my lady, I now turn to the question of what the true construction is, the way this statute works as a matter of jurisdiction. But before doing so, may I just highlight an issue, or the issue to which this gives rise and why it is important in terms of wider application. If you still have the authorities bundle at page 148, which Ms. Mayor was showing you section 388 relating to decision notices, you'll see that section 1B says, and this is important in the analysis of the tribunal, decision notice must give the reasons of the regulator giving the notice for the decision to take the action to which the notice relates. So, for example, and this is a very common situation, a regulator may take a decision to prohibit somebody. And the reason they make the decision to prohibit somebody is because the regulator has reached the conclusion they have failed to act with integrity in carrying out their regulatory functions. And if one goes to 308 of the bundle, we looked at the principles for firms earlier. These are the principles for individuals.
On page 308.
308. My Lord, Lord Justice Popplewell asked me earlier about authorised persons and approved persons. So if you see it, page 3, I apologise, 308,
Please.
tab 15 of the authorities bundle, page 308. So you see there, APA 212 sets out the statement of principles issued by the FSA to which APA refers and to which the provisions of the Code of Practice for approved persons rely. So approved persons are individuals, authorised persons are firms. But in substance, many of them are much the same. Statement of Principle 1, an approved person must act with integrity in carrying out his controlled function. So you may well have a decision notice which says person X is to be prohibited. The reason for that decision is because he has not acted with integrity in carrying out his controlled function. I also draw your attention here to Principle 2, just below it, an approved person must act with due skill, care and diligence in carrying out his controlled function. And what decision notices, at least historically, have not said, because the statutory requirement is to give the reasons for the decision that has been made, is, yes, we've taken a decision to prohibit you because you didn't act with integrity, but if we're wrong about that, and you did act with integrity, we suspect that you acted without due skill, care and diligence, and we may want to take action for that reason as well. The decision notices, because they are required to give reason for the decisions, do not historically plead what one might call an alternative case. And the issue which the hard edge of the tribunal's jurisdiction has given rise to, we can see in a case which postdates this decision, and it's at tab 96, page 2570 of the bundle. $2,570. So this is Burdett and Goodchild. So it's a different judge, Deputy Judge Baldwin. This is, you see, he has BlueCrest to consider, and you'll see from paragraph 1, this is one of those dual cases. It's both the non-disciplinary prohibition order, that is paragraph 1, subpara 1, and a fine, and that's paragraph 1, subparagraph 2. And when it came to the matter being referred to the tribunal, the authority wished to seek to make an amendment to plead that if they were wrong about their principle 1 case, their integrity case, they wished to advance an alternative case of negligence. And my lord, one sees what is said at paragraph 77 and 78. In broad summary, and I make no criticism of the tribunal in this regard, they felt that as BlueCrest was a first instance decision, although subject to appeal, obviously this appeal had not been heard, that they should follow BlueCrest unless they considered that it was convinced that it was clearly wrong, which it didn't. And what this tribunal regarded as the consequences of the BlueCrest decision, we see at paragraph 81, the first bullet point. At 171, the tribunal in BlueCrest very clearly stated that there should be a hard edge between hitherto unarticulated allegations, which form part of the matter referred, and those that do not. The hard edge is the same nature requirement, and whatever else may be an allegation of a different nature, allegations referring to different regulatory provisions will be. To adopt FCA's approach would be to blunt the hard edge. So we now have a decision of the tribunal following BlueCrest, which makes it clear that in a case where somebody is accused of a lack of integrity, it is not open to the FCA to advance a case, not open to the tribunal to find, as an alternative, that they acted with integrity, but negligently. And that, in our respectful submission, is a very surprising hard edge for any jurisdictionary scheme to have. Of course, there may be cases where that is regarded as an inappropriate amendment, an inappropriate alternative case, because it's advanced too late, or because it makes slightly different allegations, or for all sorts of reasons. But these are all matters which can be dealt with well within the ambit of the tribunal's extensive discretionary case management powers. What we are dealing with here is a matter where it cannot be raised at all, unless possibly there is some magic to raising an alternative case in the decision notice, which of itself would seem contrary to a statutory scheme which requires a decision notice to give reasons for the decision that has actually been made. So those are the practical consequences of what the right answer is to this question of the tribunal's jurisdiction. And there are, and my Lord Justice Popplewell perhaps adverted to this earlier, in a sense, two ways of looking at it that may lead the court to the same result. But firstly, one looks at what the express jurisdictional requirements are, and I will show them to you. That's really our primary case. And secondly, one construes the term the matter. And my Lord has seen it and asked for it to be shown in two provisions, but it appears in many, many other provisions. It's the matter that gets referred to the tribunal in this and other regulatory schemes. But my Lord, may I start with our so-called primary case, which is at page 121 of the core bundle at paragraph 66 of our skeleton argument, to identify it before developing the four reasons why we say it is correct. The Mayor has taken you through the provision, so it's there under the heading E3 on page 121. So we say here that the FCA's primary case is that the scope of the jurisdiction is defined by reference to the express limits in FSMA. And my learned friend Mayor has taken you through them, but you see in relation to warning notices and decision notice, there is a specific and express statutory limitation that prevents the FCA or the tribunal, as it may be, from taking regulatory action that is not within the same part of FSMA as the action proposed in the notice. And that provides an express limitation. We say it's a logical limitation, but in any event, in circumstances where the statute prescribes the tribunal's jurisdictional limit to do something different to that which the FCA did, we submit it is wrong, or at least great caution should be exercised before implying other limits into that jurisdiction, whether by way of construction or otherwise.
You say it's an express limitation on what the tribunal can do. It's an express limitation on what the FCA can do in the decision notice, isn't it?
Well, my Lord, may I just track it through? So if we go to 149 of the authorities bundle, so the starting point at 149 is section 3882 on the decision notices. And you see there at 149, if the decision notice was preceded, so at the top of 149.
Sorry, I'm a bit slow.
my fault.
I'll be there in a minute. Yep.
If the decision notice was preceded by a warning notice, the action to which the decision notice relates must be actioned under the same part as the action proposed in the warning notice. So that's the FCA. And then if we go to page 103, see section 133A1. Does my Lord have that?
Yeah.
So in determining, in accordance with section 1335, a reference made whether under this or any other act as a result of a decision notice given by a body, the tribunal may not direct the body, the FCA in this occasion, to take action which it would not, as a result of section 3882, which we just looked at, have had power to take when giving the notice. So
Sorry.
it is the tribunal that is also this clear limitation, prohibition, we say, setting clearly the ambits of its jurisdiction in these type of cases. And my Lord, the same provisions or the same result applies in the case of the supervisory notice provision. And my Lord, that is set out at paragraphs 76 to 78 of our skeleton argument, which is at page 125 to 126 of the bundle, and it may be the court would be assisted by reading that rather than necessarily reading it to them.
That relies on you having to issue a warning notice before a decision notice.
In these cases.
That doesn't jump out of the
Precisely, but there are no, as I say, as far as we're aware, there are no circumstances in which we would be, there's no provision that will enable us to issue a decision notice without doing so. So if the matter is remitted back to us, either we can take the action that's permitted, or we have to issue a new warning notice and effectively start again.
So the express limitation permits one to do anything that you could do by way of a supervisory notice. Is that?
Well, exactly. The tribunal is empowered to direct the matter to the FCA. The FCA is then empowered to do what it could do with having issued a first supervisory notice in the first place. But if it wants to do something different, it has to start again with a warning notice. So we'll look at page 99 of the authorities bundles of 1336. The tribunal can either dismiss the reference or remit the matter to the FCA with a direction to reconsider and reach a decision in accordance with the findings of the tribunal. And so the position therefore remains that whatever we can do cannot be by way of decision notice unless we start again and issue a warning notice. And that mirrors the position pre-amendment that you can see at page 16 of the bundle. At page 16, that's section 1337, the previous provisions. In determining a reference made as a result of a supervisory notice, the tribunal may not direct the authority to take action which would have otherwise required the giving of a decision notice. So the original scheme was that if you have a supervisory notice, it could be, the tribunal could effectively determine that the action taken be that which could have been taken by supervisory notice, but it couldn't direct that which would have required a decision notice. That substantive distinction remains because the tribunal can only remit to the FCA to reach a decision in accordance with the findings of the tribunal. And if that is a decision which requires a decision notice, then at least, as in response to my lady's question, as far as we understand and have reviewed the statute, we have no power to do that without issuing a warning notice to start again, effectively.
I'm sorry to be perplexed. Where does the warning notice come in if one's dealing with a...
Because effectively, if one assumes that upon remission, the decision which the authority would like to reach is not one it can take by supervisory notice, but one that requires a decision notice, i.e. something which under the original 1337 it would not have been permitted to do, because the tribunal can't direct that. Now it's not for the tribunal, it's for the FCA, but if it wants to do that and to make a decision by decision notice, it must first issue a warning notice.
I see, sorry. So it remains the position
Yes.
that the on a remission, the FCA can do anything it could have done on a supervisory notice.
Precisely.
And that there isn't, does the power to make a finding as to under 6A C in section 133, which is what the tribunal does when it's sending it back. It can make findings as to issues of fact or law, matters to be taken into account, procedural or other steps to be taken in connection with the making of the decision. So can it give directions?
It could and has.
For example, that the matter can't be dealt with by supervisory notice.
It could, in which case, as it were, the FCA would have either to make no decision and take no regulatory action, or theoretically start again.
Yeah, so it's not quite the same.
Exactly. But my lord, that's
Yeah.
right.
Thank you.
So our first of the sort of four reasons we draw attention to in our primary case is where you have a statute that expressly considers and deals with the question of the jurisdiction of the tribunal to do something different when a matter is referred to it, you should be, as a court, in our respectful submission, be cautious before incorporating other requirements. The second matter is a very short point in relation to Hansard, and it's at paragraph 75.1 of our skeleton. We can perhaps pick up the relevant quote at Authorities Bundle tab 78, page 2426. And this relates to the provision we were just discussing in 133A1, that the tribunal cannot direct the authority to take action under a different part of the statute. And this is how it was introduced in the Hansard debate, and we have it at 2426. I'll just read the sideline passage. Amendment number 275D in clause 376 is a highly significant amendment. Its effect is to restrict the action that the authority may then go on to include in a decision notice. It must be action that is taken under the same part of the bill. Thus, a proposed financial penalty under Part 14 may be reduced or replaced with a public statement. The authority cannot move from, say, a warning notice that proposes disciplinary action under Part 14 for a breach of rules to a decision notice which raises allegations of market abuse under Part 7. The authority needs some flexibility, but the person concerned is entitled to the protection of the proper notice procedures being followed. A set of proceedings begun for one purpose should not be the subject of a complete change of character halfway through. So, my lord, in my respectful submission, my lady, this provision shows the legislator's mind being specifically directed to this trade-off between the fact that in any form of contested proceedings, it's likely amendments will be required from time to time, sometimes for good, sometimes for bad reasons, but the authority needs some flexibility against protecting an applicant or the subject of regulatory action from being unduly or unfairly prejudiced as a matter of jurisdiction. And this was the answer. The provision which firstly says a decision notice can only operate under the same part as a warning notice, and then the mirroring provision on the tribunal. The tribunal cannot direct action to be taken. That would be under a different part of FSMA. And we say that reinforces what we say is a clear and logical code. The third reason that we rely on requires a little more explication, but is the very clear conclusion this court has reached in relation to the analogous regulatory regime of the pensions regulator. And when I say analogous, I do not mean that there are identical or material substantive similarities in how you regulate a pensions industry and financial services. Of course, they are different industries. But we do have two regulatory acts, FSMA 2000 and the Pensions Act 2004, introduced within 4 years of each other, that in terms of this question of jurisdiction, use pretty identical wording in terms of warning notices and then referring a matter to a tribunal and the tribunal remitting the matter back to the regulator or its panel. And I'll show you those provisions and the reasoning of this Court of Appeal in the relevant case momentarily, but our submission is it would be surprising. It is a matter for this court to have great regard to if these very similarly worded and structured statutes really had an extremely different form of jurisdictional test in this regard. So the case, which I will, if I may, spend just a little more time on, is at tab 48, page 1235 of the authorities bundle. And it's sometimes called Granada and sometimes called ITV, but in all cases versus the pensions regulator. So I will show you first the terms of the decision of my Lady Justice Arden as she then was, and then look at the actual provisions of the Pensions Act 2004. But if one goes 3 lines from the end of page 1235, my lords, my lady can see the summary by Lady Justice Arden. The appeal concerns to the extent to which, following a warning notice, the regulator can rely on grounds that it did not mention in the warning notice if its action is challenged. So one can immediately see the similarities between the issues arising for consideration. It is a novel point. It does not appear that this point has been previously considered by the Court of Appeal in the context of the 2004 Act. And then at paragraph 3, Lady Justice Arden helpfully summarises the relevant, or some of the relevant statutory provisions. So we see the procedure to be adopted by the regulator in this case is the standard procedure to which the provisions of section 96 of the 2004 Act as variously amended apply. The first step is in the standard procedure is for the regulator to issue a warning notice to persons who appear to the regulator to be directly affected by the regulatory action it is considering. An FSD, Financial Support Direction, can only be issued if the determinations panel of the regulator, whose membership is separate from the regulator's office, so decide. And that then is referred to the tribunal, and I'll show you the provisions in momentarily. But the test that the first instance tribunal applied to this novel question is set out at paragraph 30, page 1242. The Upper Tribunal therefore held that the test for allowing the regulator to introduce allegations not made in the warning notice was whether the facts and circumstances were within the scope of the matter referred, that is, the determination. Applying this test, the Upper Tribunal considered what the circumstances which the targets considered common ground were before the determinations panel, and therefore they could be aired before it. If it were proper that they should be aired before the determinations panel, then in my view, it is equally proper that they are capable of being aired again before the tribunal. So the first instance decision, and my lord, my lady will see the echoes of what we have in this decision, was that the test is really focusing on whether they were raised before at the warning notice stage. This idea that have they been argued before, and it is a matter of happenstance, but as the common feature is Judge Harrington in both first instances decisions. And this is rejected by the Court of Appeal at paragraph 60. And there are a number of matters that dictate the rejection of that construction. And paragraph 60 is one that applies with equal force in our case. it is significant that the 2004 Act does not go on to say that either the determinations panel or the upper tribunal are constrained in the conclusions they can reach by the absence of a relevant ground in the warning notice. In my judgment, the absence of a provision to that effect firmly indicates that Parliament left the question whether the determinations panel or the upper tribunal could do so to their discretion. Now, here, my lords, my lady, we again obviously do not have an express statement that the upper tribunal are constrained in the conclusions they can reach by the absence of a relevant ground in the warning notice. But what we do have, and in my submission even more supportive of the construction for which we contend, is other express limitations on the tribunal's jurisdiction in other regards, i.e. that which relates to different parts of FSMA. So we say paragraph 60 and the logic applies even more forcefully in our case, where we can, where we actually have those limitations set out. I may invite the tribunal perhaps to then read paragraphs 61 and 62. I apologise, the Court of Appeal to read paragraph 61 and 62. Now, I entirely accept that some of the matters set out in 61 and 62 are what we might call Pensions Act specific. I don't say I can mirror each of them, but it is right to note that just as protections for the subject are noted here in 61 and 62, similar protections for the subject are built into FSMA as a result of the existence of the RDC and the mandatory separation of decision making, which Ms. Mayer adverted you to, provided for in FSMA. And by reference to the last sentence of paragraph 62, starting at the first line on page 1248, furthermore, under section 103, the upper tribunal is not given a completely free hand when it makes its decision. Its power is limited to determining the reference, and it is required to remit the matter to the determinations panel with any appropriate directions for giving effect to the upper tribunal's determination of the reference, a statutory scheme we have seen mirrored in FSMA. And so they then move on to reach their conclusions at paragraph 65 and 66. So there's no threshold test of good reason, which was a submission made to it by one of the parties. I turn to consider how the upper tribunal should approach the introduction by the regulator of allegations which go outside the warning notice. The test applied by the upper tribunal in this case is unclear and unsatisfactory, and I won't read them out, but my lord will see, my lady, 5 bullet points of different formulations of the test which the first instance court has reached, many of which, in our respectful submission, it's a point we have made in our skeleton argument, in the tribunal's decision we have similarly variations on a theme in relation to what the jurisdictional test actually is, and the Court of Appeal in this case concludes, as one sees at paragraph 63, one picks it up 5 lines from the end. So I conclude that certain counsel are correct in their submissions, accept a submission in relation to a case, but the key part then on 6 lines down this paragraph, the upper tribunal can on a reference permit further evidence to be filed and receive fresh arguments, and that this supports the conclusion that it must be open to the regulator in an appropriate case to adduce additional grounds for its proposed regulatory action on a reference to the upper tribunal. And then again, if I might ask the court to read paragraph 67 to 70, because what those show is the court explaining how any unfairness can be remedied, how the statutory scheme can work properly by the robust use of the tribunal's case management powers as to whether or not to permit amendments, even though on this Court of Appeal's findings there was no hard edge in that sense.
Where is the Upper Tribunal's procedural power to stop something happening which falls outside these criteria if it appears in the original statement of case?
It's, I mean, it has exercised it, and this hasn't been challenged, by simply refusing those allegations to be advanced.
But where in the rules do we find it's got a power to do that?
Well, it has a power. I mean, what it relied upon was its ability to require an amendment to any statement of case and to manage cases in the light of the
Of course,
overriding objective.
once you've got an amendment, it's got a discretion as to whether to allow the amendment. But if we're not dealing with amendments, but the statement of case itself departs from what's in the decision notice,
Well, I can show you what it's.
where does the Upper Tribunal get its discretion from as to whether to allow that to go forward or not?
Well, let me show you.
Yeah, so we need to go to the Upper Tribunal.
Exactly.
Yes.
Let me show you how it's been done, and then I will revert to you obviously on what rules the tribunal considered it was applying. But the case you have posited is a case. It happened in a case called Seiler, which is at page 1969. Tab 61.
Okay.
So this is a different case to our one because the tribunal held that something which had originally been pleaded was something that was within its jurisdiction, but that it should not exercise its discretion to permit to proceed. And it's the case my lord is positing. Had it been an amendment, then I would have simply said I don't allow the amendment. But in this case, you see in paragraph 985, in our view, the authorities, sorry, 1969.
Sorry, give me a minute. 985.
Yeah. In our view, the authorities demonstrate in relation to references concerning prohibition orders that the tribunal has jurisdiction to consider allegations based on facts and matters which were considered before the RDC whether or not those facts and matters were relied on in the relevant warning notice. However, whether or not the authority should be permitted to rely on matters which were not relied on in the warning notice is another matter. As was indicated in Khan, the position may well be different where the facts and matters concerned could have been contained in the warning notice were not. In those circumstances, in our view, the tribunal should have regard to the overall purpose of the statutory scheme and the place of the tribunal in the regulatory process and consider whether it should exercise its case management powers to prevent the authority relying on a matter which was not relied on in the warning notice. And I will come back tomorrow morning, so I'm sure somewhere I've got what, because I was on the other side, and
Can I ask him to look at 999?
and 999 as well also sets that out. Oh, I'm very grateful to my learned friend. It follows that there would need to be an application from the authority to rely on the facts and matters concerned, even if those facts and matters are referred to in the decision notice. In determining that application, the tribunal will take into account all the relevant factors in this case and apply the overriding objective in Rule 2 of the Tribunal Procedure, Upper Tribunal Rules 2008, to deal with the matter fairly and justly. And I'll get to chapter and verse as to what those provisions say overnight. But
So it's my fault, I'm just not quite following. It follows from what? That you have to make an application to rely on something that's in your statement of
something that
case?
was your statement of case, but was not contained in the
But what's this tribunal saying that follows from?
It follows from the Arden case. And I think what this tribunal is basically saying is that the way it's interpreting Granada and my Lady Justice Arden's decision is that if something new is to be advanced, it is not a matter of happenstance as to whether it is raised by way of amendment or raised by way of subsequent pleading. What matters is the substance of whether or not they should.
Well, I follow that that's a sensible conclusion to reach, but how does one do it under the rules?
The answer may be in Rule 5.
Yeah.
We have got the Upper Tribunal rules.
Is it Rule 5 and Rule 2? Yeah.
Just remind me where they are.
So it's 275. I'm very grateful.
That's Rule 2, but I think it's case management plans in.
Sorry, Authorities Volume 1. Is it?
So permit or require a party to amend a document.
Sorry, I haven't got it yet. Where is it?
Page 276.
Of Authorities 1.
Back of Authorities Volume 1.
Yes, I apologize. Authorities 1, tab 12.
Thank you. So 5.2 you say is what
Yes.
it.
Read with the overriding objective. So it's,
That was 5.3c, I think.
yes, permit or require a party to amend a document.
But on your case, as I understand it, Mr. George, that you say this is entirely a matter for case management and discretion.
Subject to the express hard edges I have shown about a different part of FSMA,
Exactly.
but yes.
But you say that, as I understand it, on your primary case, you say that's the only hard edge.
My lady, yes.
So, subject to the exercise of case management discretion, you could bring forward a completely case.
Which would clearly, as we have seen from the Hansard, be likely to fall foul of any case management decision in this regard. But what both this tribunal and the Pensions Tribunal have proceeded on the basis of, and nobody here is suggesting they were wrong, as it were, or has done hitherto, is that if somebody attempts to do that in their original pleading, the tribunal is able to consider that and strike it out as a matter of discretion, just as it would if it was advanced by way of amendment. So I have shown you the way the tribunal did that, and we've looked at the rule. And the it follows that provision, my lord, was it follows from what my lady, Lady Justice Arden said in Granada at paragraph 67, 1248.
And is it those paragraphs that have been cited in the
Sila case,
Just
yes.
Petals too?
It's 67 to 69 are cited at 997 of Sila. In my judgment, the exercise of the Upper Tribunal's discretion to allow the regulator to raise a new case not contained in a warning notice should depend on a consideration of all the relevant factors in the case, and not just the narrow question whether the regulator had good reason for seeking to enlarge its case. The Upper Tribunal has to weigh up all the facts and circumstances in deciding whether to permit the regulator to adopt a new case, and then a number of those considerations are set out. But this is not a simply, is this an amendment point? This is your actual case, whether amendment or whether as originally framed to the tribunal, one which should not be permitted because of these case management powers and these case management principles, which I am sure, I don't want to preclude everything, but in principle, my lady, one can quite see why the example you posit about a complete change of character of the proceedings halfway through would be likely to fall foul of it. And we have seen how the tribunal in the financial services context, quoting here from Mrs. Justice Arden, have exercised its case management powers under Rule 5 and Rule 2, as we just looked at, to require somebody to remove something which they had originally pleaded. And that must make sense. In a sense, whatever the jurisdiction in a regime like that, like this, there is obviously scope for discretion, even on the tribunal's hardest edge, or on my no edge, as I think my lady puts it. And that discretion must be exercisable, regardless of whether it's pleaded originally or whether it's pleaded by way of proposed amendment. And as I say, we can see in Granada and Silo that both of these similarly constituted tribunals have felt able to do that. So my lords, my lady, may we just look then back at Granada, at what the actual statutory revisions are, because we've got them helpfully in a list. And that's at 1250. So at 1251, and this is back in tab 48, one sees at the bottom there section 96, standard procedure. 1A, 3 lines from the end, in any case where a warning notice is given to any person in respect of a contribution notice, over at 1B, the requirements what the warning notice must contain, and then 2, the standard procedure is a procedure excuse me, which provides for A, the giving of notice to such persons as it appears to the regulator would be directly affected by the regulatory action under consideration, a warning notice, B, those persons to have an opportunity to make representations, C, the consideration of any such representations and the determination whether to take the regulatory action under consideration, the giving of D, the giving of notice of the determination to such persons as appear to the regulator to be directly affected by it. They call it a determination notice, not a decision notice. E, the determination notice to contain details of the right of referral to the tribunal under subsection C. And the lords and ladies can see the rest of those provisions. And then at 96.3, where the standard procedure applies, the determination, which is the subject matter of the determination notice, may be referred to the tribunal by, and then various people are set out. And then down the bottom at section 103, subsection 3, on a reference, the tribunal concerned may consider any evidence relating to the subject matter of the reference, whether or not it was available to the regulator at the material time. And 4, on a reference, the tribunal concerned must determine what, if any, is the appropriate action for the regulator to take in relation to the matter referred to it. 5, on determining a reference, the tribunal concerned must remit the matter to the regulator with such directions, if any, as it considers appropriate for giving effect to its determination. So we have warning notice, we have reference, and we have the matter being both referred and being remitted. It is, in my submission, a fair and accurate contention to say, as we do, that this is a structurally, materially similar, and on any view, relatively contemporaneous statutory scheme. And it does, as my lady has pointed out, and I entirely accept, effectively have no hard edges at all, for the reasons that my Lady Justice Ardent set out. I obviously do, on my primary case, have some hard edges because there are statutory provisions to that effect that I have shown you.
Just working out what the matter referred is, it's possibly a bit easier to follow through in this legislation. Because of the way I think it's made reasonably clear that the determination notice is the matter referred.
So for 3, the
Sorry,
determination.
3, the determination, which is the subject matter of the notice, may be referred. That's possibly a bit easier to track through than.
It is possibly, and I want to be very clear, I'm not saying they are identical, statutory language, I'm relying on the similarities, but one also has to also recognise that 1034 does say on a reference, the tribunal concerned must determine what, if any, is the appropriate action for the regulator to take in relation to the matter referred to it. And FSMA also has these references to matter and subject matter in relation to various places. So one can see at 1333 on page 16 of the authorities bundle, on a reference, the tribunal may consider any evidence related to the subject matter of the reference, whether or not it was available to the authority at the material time. So in my respectful submission, we can see the analogies between the structures and the procedures set out in these two regimes gives considerable weight to the contention I advance in support of my primary case, that effectively the same test applies in the tribunal, and the very broad and powerful case management tools available to the tribunal, which it has certainly shown itself capable of exercising, and we've seen in the other cases, this isn't a theoretical submission, provides sufficient protection. And if one perhaps looks at it the other way around, from a point of simply principle, I mean, what is it that a hard-edged jurisdiction really provides that a tribunal with the full remit of case management powers we have identified gives? What policy would really say we must absolutely stop the tribunal having a jurisdiction and make it this hard-edged? As opposed to, on the other hand, what you lose by this hard-edged jurisdiction, which is the opposite in a sense of what my lady posited to me, not where you seek to change the entire case halfway through, but where you seek to make a relatively minor and common sense tweak, possibly because of material you weren't or even couldn't have originally been aware of, but run up against this hard-edged distinction. Now, there is one other paragraph in Granada to show, and that's back at 1248. And that's at paragraph 72. And in a sense, one has to get keep the chronology in mind. Said Mr. Stallworthy, who you may recall succeeded in his submissions back at 63 and has achieved his goal, relied on cases decided under FSMA as showing that the regulator was not bound to stay within the terms of the warning notice. And rather oddly, this is at a time where the FSMA authorities were much less hard-edged than this BlueCrest decision is. But in any event, those authorities were not considered of assistance. But in my submission, that does not mean that the converse is true today. In 2016, the Court of Appeal had before it a novel and important point on the construction of the jurisdiction of the Pensions Act, and it did not find of assistance 3 or 4 authorities decided under FSMA, which related to different issues, but had various obiter dicta or comments which might be prayed in aid. I'll show you some of these decisions as I move on to my secondary case. But the position is in my submission quite the reverse as we sit here today in 2024, because we have the fully reasoned and fully analysed decision of Lady Justice Arden in the Granada case on the very point which this court is considering in a different statutory regime. And secondly, we have a much harder edge now under the BlueCrest decision, the decision under appeal today, than would ever, in my submission, have been envisaged when we looked at the earlier authorities from the tribunal.
And we are in a position on the submissions we've had to compare any differences between
Yes,
FSMA and the pensions.
precisely, my
Which
lord.
Lady Justice Arden said they weren't in that case.
My lord, exactly, and not least, as it were, because they didn't, now we have this reasoned decision, we can see what mattered to Lady Justice Arden, and as I have attempted to do, track it across, or not track it across, if I can't, to the FSMA regime. That's what we can now do, because we have this decision. So it's very different now, seeing if Granada can assist this court in its task under FSMA, than it was back then. So we do say that, in a sense, Granada provides the right answer. I don't say it's binding, because it's a different regime, but for this court, considering this matter, particularly when looking at the primary jurisdictional requirements, the express jurisdictional requirements in FSMA, and what was said in Hansard, and indeed what this Court of Appeal has said in previous cases under FSMA. And I'm going to deal with this briefly, because there is a point taken against me that has some validity, that these are two cases that weren't dealing with the issue head on, as Granada does and as this court now does. But nonetheless, they are, in my submission, instructive, as they are the two Court of Appeal cases relating to this regime which touch on the relevant issue. The first is Hobbs, which is at Authorities Bundle, tab 45, page 1125. And in this particular case, as you may have seen, Mr. Hobbs was accused of market abuse and of having given unfit and improper, dishonest, I think, answers in relation to interviews. He was then found to have lied before the Upper Tribunal itself, and the latter clearly not a matter that could have been raised in a warning notice or decision notice because it postdated them. You see at 1134, and this point is made, and I'm quite happy to accept it, that there was common ground rather than argument on this point. The issue of statutory construction concerns the meaning of the matter, which a person subject to a decision notice is entitled to refer to the tribunal. Happily, Mr. Jaffe and Mr. Hunter agree the expression should be given a wide meaning. The matter includes, and I emphasise includes, the facts and evidence referred to in the decision notice on the basis of which the authority concluded that the person in question was not a fit and proper person and that a prohibition order was appropriate. Clearly, those are not going to include what he then did before the tribunal. And the reason this became important was because the tribunal actually cleared him of market abuse. So the lying became determinative, not just a sort of subsidiary matter. And this Court of Appeal held that the FCA was entitled to rely on matters by definition not in the warning notice, because they hadn't occurred at the time of either the warning notice or the decision notice. And he says this at paragraph 38. Furthermore, in my judgment, it is important for the tribunal to consider all the facts and evidence put before it on a reference under section 57. There are two reasons for this. The first is that its consideration of a reference is not ordinary civil litigation. I do apologise. It's 1135, yes. Paragraph 38. And perhaps if I ask the court to read it to itself, that may... So the Court of Appeal, Sir Stanley Burnton, going out of its way to emphasise the importance of the tribunal considering all of the facts and evidence put before it on a reference, even whereas here the allegation related to something self-evidently not aired at an earlier stage. And obviously...
There's a reference there to Henderson and Henderson. I was just, what are your submissions? Suppose you're wrong about this. Could you start again and bring up an alternative case? Or is this something we need to concern ourselves with?
It was certainly, and you see it there, a reason that Sir Stanley Burnton gave for not requiring the matters to be brought back again that Henderson and Henderson points could arise,
I can see that.
I would be, in a sense, he's right. I mean, I'd be nervous about giving a definitive answer because I can see if I'm wrong about this, it will arise at some stage where the authority seeks to start again and somebody says it's Henderson and Henderson. And I think it would be wrong of me just to proffer an answer. But it's clearly, in my respect for Mr. Stanley Burton is right, that that's the sort of issue that will arise if you have this, well, you could and should have done it and you didn't at the right time and that type of point. So in my submission there is compelling assistance from that case, and I just emphasise while we have it on paragraph 1, page 1127, once these 4 lines from the end, it decided to impose a large financial penalty on him and to impose on him a prohibition order pursuant to section 56 of the Act on the ground he was not a fit and proper person. This is yet another of those dual cases that are both disciplinary and non-disciplinary. And that is obviously relevant because, as we'll come on to, my learned friend's case, at least advanced on appeal, is that maybe you can construe matter differently depending on whether it's disciplinary or non-disciplinary. But most of these cases really involve both, and it would be very odd if you construed the matter in a different way in our respectful submission. The other case in this regard is Wilford, and that's back at tab 44, page 1101.
Just before we look at that, I'm thinking, oh, sorry to raise this thing, but about starting again. Are there any time limits on you taking action?
Yes, in some cases.
Yes, in some.
So, I mean, I won't go through them all, but for example, to bring to fine an individual for misconduct has a time limit.
Yeah.
To fine a firm does not. And there are various other such distinctions. But yes, time limits may arise.
So that might be another reason for not requiring you to start again if you haven't pleaded it correctly first time round. Or something.
Precisely. It's certainly the consequences of requiring you to start again are extremely severe, possibly determinative in a Henderson and Henderson or limitation point, certainly costly for everybody in terms of going through the rigmarole of the same procedure, you know, for, as you say, let's assume a lack of clarity in the original pleading or something that, you know, that something that a civil court and civil litigation would permit as an amendment, having weighed all the considerations up. To require in each case that to start again creates, as I say, possibly determinative, but certainly a procedure that is inimical to the overriding objective in terms of what it costs and how long it's going to take. And nothing is achieved by the hard-edged jurisdiction that could not be achieved by proper exercise of case management powers if there is a good reason why the amendment should not be allowed, for whatever that reason may be. You know, people have sat on their hands, people have simply given representations, people have got witness statements, all sorts of reasons. We know that in amendments always give rise to these type of considerations. The later they are, the more important they are. But to have a hard-edged jurisdiction has really, really severe consequences. So Wilford's at tab 44, page 1101. And well, I think my Lord Justice Nugee referred earlier to the alternative remedy point. So this was a case where somebody did try and judicially review a decision of the RDC without going to the tribunal. They said that the RDC had not given sufficient reasons, and because the tribunal couldn't give reasons, it just determined the matter afresh. He effectively had lost something of value. And this was one of the cases I said that was the argument. It was rejected and held by the Court of Appeal that the alternative remedy has to be pursued. Its relevance for these passages are a matter at paragraph 37, and we can pick it up at 11:15. So that was the nature of the argument, and the argument from the authority, accepted by the Court of Appeal in the end, was, well, there's no value. The alternative remedy encompasses the fact that you haven't had reasons, because once you get a judgment from the tribunal, you will know the truth, the full reasons. So it's wrong to really say that there isn't an alternative remedy. And a point being made was that the FCA could put forward lots of new allegations that had previously not been considered if he went to the tribunal, and that was a reason for allowing him to judicially review the FCA. So my lord sees, my lord, my lady, if we pick it up at 11:15, 7 lines down, my lord, Lord Justice Morbick, giving this decision, refers to the risks that the FCA might put forward additional allegations and that the tribunal might increase the penalty are there and have to be taken into account. As I say, I appreciate that's not what the argument is about, but it is nonetheless a consideration and one that is taken into account in the conclusion of my Lord Justice Morbick, that the ability to advance additional allegations before the tribunal is there. Now, obviously, these are not in many ways as powerful as Granada, because that is a reasoned conclusion on the same analysis of a statutory scheme. But they do, in my submission, show that at least as far as this Court of Appeal is concerned, it historically has recognised, or at least has not in any way suggested, there is this hard edge of jurisdiction which we now come up against. And the final matter I draw attention
So do we
to...
just before we leave that,
Of course.
is the end of paragraph 6 relevant to the same effect? One reference.
Precisely.
The FSA may, if it thinks fit, broaden the scope of its allegations.
Precisely.
Provided they relate to the same matter. Whatever that means.
Well,
I mean, and I'm conscious in labelling them primary and secondary case that they're going to have to interrelate together at the end of the day because the word, the matter is there. But my primary case, and that's why I've been very happy to adopt my lady's characterisation, is that the matter has the widest possible meaning and effectively the only hard edge of the jurisdiction are those express limitations. And that is what has effectively been held in Granada. And I'm not trying to pretend the matter doesn't exist, it obviously is there. It's the widest possible scope of my respectful submission. So I'll now turn to the secondary case. I had one more matter, just one more item just to look at in the context of the primary case, and that's the judgment itself at paragraph 48, at page 247 of the bundle. This is what is said here. The words subject matter of the reference and matter in respect of which the tribunal must determine the appropriate action are not defined. The provision is, as the title indicates, a general provision which caters for appeals as well as references to the tribunal from decisions of a variety of regulatory bodies in relation to financial services as well as the authority. In its broadest terms, reading 2085 and 1334 together, the subject matter of the reference in this case in relation to the DN is the decision of the authority to impose a financial penalty on the applicant. However, as we shall see, the authorities give a narrow interpretation. So even the tribunal, unconstrained by the authorities which we will now look at, seem to accept the logic of the submission which we are making in relation to the natural meaning of the words of this statute. And as I have shown, there are authorities at this court level, both in the pensions case and in the financial services context, Granada, Hobbs, Wilford, which support that, that primary reading, or my primary case.
So what is your submission on what the matter means?
On my primary case,
Yes, on your primary case.
in my submission, may I refer you to paragraphs 96.1 and 96.2 of our skeleton at pages 134 and 135. And I would adopt the decision in Khan. You see a noun which is apt to include as broad a section of relevant material, however it is categorised as possible. Reading with that what I say at 96.2c from the Australian case, the widest term to denote controversies which might come before a court of justice. And I'll show you those passages in context, perhaps in due course. But on my widest case, I say that is the ordinary use of the word the matter.
Do you say that the starting point for working out what the matter is the decision of the authority?
Yes, read with, of course, those statutory limits as to what the tribunal can do in relation to that. Exactly, but yes. Yes.
I'm just trying to work out the starting point.
Yes.
In a sense, the complaint to the tribunal is, in this case, the decision to impose a penalty and the decision to
precisely
order redress.
Precisely. And I mean,
But that clearly can't be the finishing point, and certainly isn't on your interpretation, not least because of the tribunal's power, the power to end up doing something different.
Yes.
Albeit under the same part.
Precisely. And so, I mean, what we say, and obviously there can be cases where you have different action within the same part, but we said the right result, what is being referred, the decision to impose a financial penalty, the decision to impose a requirement upon this firm, maybe the requirement to constitute a redress scheme, is the widest. The matter refers to that as a word apt to give as broad a selection of relevant material in relation to that matter, however it is categorised, as possible. And so that does permit us to rely on new facts and matters, including the relabelling, where we are still, and in this case, we are not seeking to change either the action of a redress scheme or the action of imposing a financial penalty.
So the focus, if you like, is on the decision, not on the facts and circumstances which led to that decision.
But it can be those as well. As I understand it, you say the matter includes all of the following. One, the decision, imposition of the penalty, and therefore allows whatever the reasons that were given for it, and allows any other reasons to be advanced for the same penalty. Two, any of the facts and matters which were relied on for the decision, even if you're seeking a different decision in the tribunal.
Yes.
Three, tell me if I'm wrong about any of these, any of the facts and matters that could have been relied on in reaching the decision but weren't. And four, I think you say, any facts or matters whether or not they could have been relied on, so that in theory there is no jurisdictional bar on seeking a different decision on different grounds in relation to facts and matters which were not identified at the time and possibly did not exist.
Lord, yes,
it's all of those.
Yes, my lord. And as I say, that's, I think, in a sense, that was the no edges at all which my lady put to me earlier. That is my primary case. I will turn in a moment to show you a very different definition on my secondary case, which is a definition of the word matter. But for the reasons I have adumbrated, and particularly by reference to the analysis in Granada, in my submission, that is what that case is saying is the right construction of that statutory scheme. And it is not, in my submission, as surprising or drastic as it will be submitted to you by my learned friend, because of the case management powers the tribunal has to prevent anything. But my lord is right.
You say category 4. You haven't got much chance of
precisely
of
my
getting
lady,
through, but that's not a jurisdictional
Unless it's
question.
line to the tribunal, for example.
which couldn't have been.
You would say it does include some of that.
Yeah, well, precisely.
Well,
that falls within.
But you may still be in category 1 then, because you may just still be seeking the same
Yes.
penalty.
But yes, I mean, in a sense, and if I will reflect on the transcript overnight, and if there's anything I feel my lord has missed out, I will add it in, lest there be any thought to be shying away from the width of the proposition.
Well, and you may be able to give a different and more helpful waterfall, because one of the things we may have to consider is whether it's 1, 2, 3, and 4, or 1, 2, and 3, or 1 and 2, or
Precisely.
whatever it may be.
But having made that primary case, let me move, as it were, to the secondary case, where, for reasons which I commend to this tribunal and invite this tribunal to adopt, but are set out at some length at paragraphs 95 to 97 of our skeleton, and that's page 133. And this is a different waterfall. It's a much narrower waterfall, and it basically follows the logic and analysis not of Granada, which is my primary case, but of Jarbret and the Upper Tribunal. And so you'll see it there. The term matter encompasses anything that arises from the same factual situation which gave rise to the regulatory action and the statutory notice referred to the UT, or is otherwise connected with the circumstances, the evidence and or the allegations, whether factual or legal, that were before the FCA's decision maker. So this now does provide more hard edges, a connection to the original decision, which, as my lord has recognised in his list of requirements, is not necessarily present on our primary case or in Granada. But in this secondary case, we very much look to say what we say is the most logical definition, following not just what one might call common sense and the fact that I think, as my lord has adumbrated, this court may feel it needs to give a definition to matter, which is narrower than my rather all-encompassing one. But it also follows the reasoning of the cases of the tribunal, including Jarbret, the probably most famous one from 2006, which is at page 679 of the authorities bundle. I apologise, tab 35, is it? Yes, 35.
Thank you.
Now, Mr. Jarbret's case was a case where the warning notice alleged that Mr. Jarbret had acted with a lack of integrity and should be prohibited. That allegation was rejected by the RDC, but was obviously before it, who held that Mr. Jarbret had not acted without integrity, but had failed to exercise due skill, care, and diligence. And when Mr. Jarbret referred the matter to the Upper Tribunal, the FCA sought to plead its original case, namely that Mr. Jarbret had acted without integrity and should be prohibited. And at that time, the distinction between disciplinary and non-disciplinary references didn't exist, so we're back in the old regime. And if we go to paragraph 682, we can see at paragraph 14 that this was again a case involving both prohibition and a financial penalty. And in determining what the matter was, obviously a lot of the focus on the argument, respectively on both sides, was on how unfair it was for the FCA to change its case after its own decision maker had rejected the allegations, versus the FCA's case, that effectively it should be allowed to plead a case which had always been its case right from the start of the warning notice. And it's in that regard that we get to paragraphs 28 to 31, which is the reasoning of the tribunal. I should say what the result is. The result is the FCA was allowed to reintroduce an integrity case. And that's why I said that the tribunal authorities have really changed, because in 2006, under Jarbret, that was permitted. Following this BlueCrest decision in 2024, as I showed you in Goodchild and Burdett, that position no longer pertains. But the reasons in this case, and I'll start with the conclusion of paragraph 31, these provisions set out what seemed to us to be a clear code as to the tribunal's jurisdiction, which enables it to depart from the authority's decision when determining the matter referred to it. And what is being referred to there, my lord, perhaps you just glance at paragraph 30, you can see those are the provisions which I have called my express limitations. Those are the thou shalt not take a decision within a different part, thou cannot direct the tribunal to do that which couldn't have been done by supervisory notice. These provisions set out what seems to us to be a clear code as the tribunal's jurisdiction, which enables it to depart from the authority's decision when determining the matter referred to it. Any direction given by the tribunal to the authority to take action must in the first place be under the same part of the Act as the decision set out in the original warning notice, and in the second place, the tribunal's direction must not involve substituting a statutory remedy for which a decision notice is required for one for which a supervisory notice is required. It must, we think, follow that the Act expressly contemplates the tribunal determining as appropriate action for the authority to take an action of a different nature to that covered by the decision notice. So the FCA succeed in this case, and in my respectful submission, the conclusion of paragraph 31 is pretty identical to the primary case that I advance, in that it is really starts and is guided by these express statutory limitations which are at the forefront of my statutory case. And this is why Jarbret was sought to be relied upon in Granada in support of the conclusion which Lady Justice Arden reached. But what have become focused on in this case is another statement at paragraph 28. So before they get to the conclusions, they consider what the matter might be. And we can pick this up at line 36. It is the allegations made in the decision notice and the circumstances on which these are based that fall to be considered and evaluated. They comprise the matter referred. It is in relation to those circumstances and any further relevant evidence that was not available to the RDC that the tribunal's functions to determine the appropriate action for the authority to take. The indications so far are that the circumstances, the evidence and the allegations before the RDC and not the decision are the subject matter of the reference. And then one goes on to 29. The second point is that in the present case, the facts and circumstances on which the authority relies in its statement of case were before the RDC. They are either set out within the decision notice or recorded in the decision notice as matters on which the RDC committee did not reach a concluded factual finding. In this respect, to be said, the facts and matters before the RDC are the facts and matters relied upon by the authority for the purposes of the present reference. This is not a case such as Parker, where a new allegation unconnected with the factual context that gave rise to the original decision was sought to be raised. So the conclusion I have shown you at 31, which effectively in my submission aligns with my primary case, but right it is, there are these definitions of the word matter in 28 and 29, and obviously particularly influenced by the nature of this case, which was a warning notice case rejected and decision notice case allowed. But in either case, in my respectful submission, what we are seeking to do by the third and fourth contested amendments clearly falls within this interpretation of Jarbret. And we, as I say, in our skeleton argument at paragraph 95, we have set out a slightly fuller explanation of the logic of which Jarbret, leads in circumstances where obviously not all decisions, in fact many decisions, will not go through the RDC. But on this secondary case, applying the Jarbret logic, I am accepting there has to be a connection with the original decision and the facts and matters arising in the original decision. As I have said at paragraph 95 of our skeleton, we try to express that connection in respect of the various matters as precisely as possible. But it is not a connection that precludes the type of amendments which we seek to make in this case, which I have characterised as relabeling, but in my submission, just as a factual connection can be established on the basis of similar facts or allegations which add to or relate to the same nature, so a relabeling is clearly connected to the original allegation. And as I say, the way we put it at paragraph 95 of our skeleton argument, anything that arises from the same factual situation which gave rise to the regulatory action, the statutory notice referred to the UT, or otherwise connected with the circumstances, the evidence and or the allegations, whether factual or legal, that were before the FCA's decision maker. That is a definition of matter in our submission, which allows for a jurisdictional limit in line with a sensible policy without creating unwarranted and unjustifiable hard edges. And it follows from the nature of the analysis taken part within Jarbray.
Well, that's a much wider formulation than you actually find in Jarbray.
My lord, yes, because Jarbray is focused in the steps of the reasoning on the particular matters argued and relied before it, which involved a contested RDC hearing and the particular feature that an allegation had been raised at warning notice stage and then rejected. That clearly provides, in my respectful submission, a sufficient connection. But the logic of what is set out there, particularly when read with paragraph 31, clearly equally would allow, and in fact it did in this decision. I mean, the whole point is it is a different regulatory allegation in that what is being said is that he has acted without integrity. He should be prohibited. It is a different regulatory allegation to that which was set out in the decision notice. And in my respectful submission, the connection with the original context, there is no principle in construing the word matter for whether in fact there was a contested procedure, there may well not be in many cases, whether the RDC were involved, and if they were, whether an allegation was made or rejected. Those are, in a sense, matters of happenstance. The connection arises, as you do in other contexts, and I'll show you the Limitation Act in due course, the connection arises from looking at the original allegation and what is now sought to be raised, and as set out in paragraph 95, applying a legal test, but a relatively common sense one, as to whether they are, on my lady's example, or as that example of Parker, seeking to change something so dramatically it cannot fall within the scope of the term, scope of the relevant matter, or whether it is the type of amendment, on which one would expect a regime to permit, because it has that connection with that which the tribunal is having to consider. And may I briefly, my lord, because I looked at these earlier and I'll do it briefly, but the draftsman in choosing to use the word matter was not in entirely uncharted territory. There are legal authorities, and we have referred to some of them at page 134 and 135 of the bundle. Of the core bundle. I won't take you to a dictionary definition for the second time today. You've seen what they look like. It's at the last sentence of paragraph 96.1. Natural meaning of matter, a situation or subject that is being dealt with or considered. The cases are all in the bundle, but it's not really that they have analogous facts at 96.2 A, B, and C. It is that they look at the exact word matter. So you see in Khan, a matter that could have been raised in appeal is a noun which is apt to include as broad a section of relevant material, however it is categorised as possible. And then two Australian cases, Pines and Bannerman, matter in the phrase a matter that constitutes or may constitute a contravention of the Act in its ordinary sense of an affair or thing as a body of facts which constitute or may constitute a contravention. Matter comprehends, going over the page, the conduct of persons and the circumstances attendant of it. And as I said earlier, from South Australia and Victoria, the word matters was in 1900 in common use as the widest term to denote controversies which might come before a court of justice. I appreciate cases from a long time ago and a long way away, but the point I seek to derive from them is that if my lord decides that actually my primary case is too much, we must define the word matter as our secondary case. It's important to note that word is historically and across many jurisprudential contexts regarded as one of extreme width. It is a draft person who is looking to give the widest possible connotation to that which they are drafting about. And in my submission, when one looks at Jalbret and the true construction that should apply to it, these are of great assistance in deciding what should happen in this situation. So we commend, as our secondary case, the definition put forward at paragraph 95 of our skeleton argument.
Is it different in substance from your first submission? Because it seems to me that it's defined or might be recharacterised as defining what is permissible as anything which a tribunal might probably consider as a matter of case management ought to be allowed to be brought before it.
That, in my submission, is certainly a fair characterisation of my primary case. It would not be, in my submission, entirely fair characterisation of my secondary case and what I say at paragraph 95. Because on that definition of the word matter at paragraph 95 of my skeleton, I am presupposing a requirement for a connection between the original circumstances of
a connection, but a connection with what you then use quite a broad range of wording to.
Yes, my lord, I accept that.
And if it's got a connection with any of those,
but there is a distinction, and it perhaps comes from my lady's example of somebody seeking to change the character of a case halfway through by introducing a completely different allegation. Now, we can posit different circumstances, but I can see it would not be enough in my formulation at 95 to say, even though this is a completely different allegation about completely different context in a completely different date in a completely different country for a completely different firm, it's still somehow connected because it's the same person.
Well, I understand. All I'm saying, it comes to the same thing, because under your first submission, you wouldn't be allowed to do that either.
But as a matter of case management, as a matter of, exactly.
As a matter of case
My lord
management,
is quite right.
rather than a matter of jurisdiction.
Exactly. I mean, and this
So-
is why I do emphasise the submission that when one's considering as this matter of statutory construction, what is the purpose of the statute? That there is nothing that a hard-edged jurisdiction gives you that robust case management cannot give you, other than some bizarre no-go areas that you can do nothing about. And that's all you get. You get problems, you don't get solutions. Whereas with case management powers, you can solve the problem of the amendment or a case being raised that you say, well, no, this shouldn't be allowed. For whatever reason, that's what the tribunal can decide. It doesn't have to be a matter of hard-edged jurisdiction. In the last 3 minutes, if I may, I'll just deal with what I've called my tertiary case, but my lady perhaps rightly just calls relabelling, which is certainly turning everything round and saying, well, if you're not with me on that primary case, then you're not with me on the secondary case. Just this amendment, what it is a change from one rule breach, prenate, to another, Prin 7 and Cobbs 421. We are not changing any of the facts within that allegation. We are simply labelling it in a different way for the reason that you understand, because of the way the redress argument has played out. And I will just show you, if I may, a potentially helpful analogy at page 140 of the core bundle. And that's paragraph 102 of our skeleton. So my lord sees here, and my lord and lady will be very familiar with it, section 35(5)(a) of the Limitation Act. A party may amend its statement of case to add or substitute a new claim after a period of limitation has expired, if the new claim arises out of the same facts or substantially the same facts already in issue. And one of the cases in which this was considered was Höchst and Inland Revenue Commission, And we see that at page 526, tab 30 of the authorities bundle. So we're looking here at the question of what a new claim is, something that falls foul of the Limitation Act provisions. And Mr. Justice Park identifies at paragraph 24 two critical concepts which feature in the foregoing formulations of the legal position are those of a cause of action and the limitation period. A cause of action in this context is not so much the label attaching to a claimant's claim, for example, breach of statutory duty or money paid under a mistake of fact, a mistake of law. Rather, it is the set of facts which entitles the claimant to relief. And every fact is material to be proved to entitle the plaintiff to succeed. Every fact which the defendant would have a right to reverse. And then on, a cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. So, my lord, clearly it is a different context, and the cause of action is not necessarily a concept which arises in regulatory proceedings. But the analysis in my submission is instructive. That if I'm right about a connection test, even if I'm right, or even if the conclusion is that Jabret, on its narrowest formulation, the facts and circumstances before the Regulatory Decisions Committee is allowed, in situations where you just change the label, that has to fall within any sensible limits to the tribunal's jurisdiction. It's not the label attaching that matters. It is the set of facts which entitles the claimant to relief, or entitles the claimant to impose a fine, entitles the claimant to, or the authority to impose a redress scheme. So in our respectful submission, on any view, this amendment, the third and fourth amendments, should be allowed. Now, my lords, I get 1 hour from 10 o'clock tomorrow morning, and then I sit down and my learned friend speaks, but unless I can assist you, and I will obviously answer some questions that you gave me tomorrow morning in that hour as well, but unless I can assist you further this afternoon.
You're on course, are you?
Yes, that is a hard-edged jurisdiction.
That's a very hard-edged
I'm
jurisdiction.
certainly not going to rub up against it.
But I am very grateful to parties for agreeing to sit the times we've adjusted it to accommodate my commitments. Thank you very much. All right, 10 o'clock.
All rise, if needed.